I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're Davis Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law. I'm going to talk a little bit about the military family leave provisions. These amendments to the FMLA regulations have been in effect now for about a year. They came into effect in March of 2013. The regulations for military leave and caregiver under the FMLA are I would say they're very complex. They're detailed, and there are a lot of traps for the unwary in there. So I'm just going to pick out a few. I could do a whole day or a half a day presentation just on these amendments to the regulations alone, but I'm just going to hit a couple of high points for you and then move along. But the overriding message is that these regulations are quite complex, and there may be some hidden rights or hidden obligations that you may not be aware of. So we'll start off. You have an employee who requests FMLA leave to arrange for the transfer to a hospice care facility and to work with the hospice staff for the mother of the employee's son. So your employee comes to you, says, I want to take FMLA leave so I can take care of my son's mother and arrange for her hospice care and medical treatment. My son, I'm the employee, my son is serving in the Navy, not in a war theater of conflict, but is on a deployment sailing the warm seas of the Mediterranean. But his mother needs medical treatment and care, and I'm coming to you and I'm going to say, I want to take FMLA leave. So you are required to provide this as unpaid leave. Obviously, by the way I've presented that, the answer to that is true. Under the military family leave provisions, there are two classifications of additional leave that were provided for the benefit of active service people and veterans as well. And one of them is you've got the qualifying exigency leaves, and I'll talk about that, as well as military caregiver leave. So that's when an employee comes to you and says, I want to take a leave to give care or care for a qualified military person. So you got two groups of leaves that are encompassed under the FMLA: exigency leaves on behalf of someone serving and someone deployed under active orders, as well as caregiver leaves. So this one I took, and this is actually one of the exigency leaves that's identified in the regulations to care for a covered military person's family. So it doesn't have, notice that your employee is not asking for leave to take care of his or her mother. There's not a direct familiar relationship between your employee in this scenario and the person requiring the hospice care, but that person requiring the hospice care or the medical treatment is the mother of an active military member deployed on orders. So that scenario, under these regulations, your employee has the right to take up to 12 weeks of unpaid FMLA leave. Some of the other qualifying exigencies, again, this is in the category of leave, FMLA leave for exigency circumstances for covered military members, would be to make arrangements in a military member's short notice deployment, where a military member is deploying within 7 days or less. And remember, the military person in this scenario is not your employee. Your employee is either the parent, son, daughter, or next of kin of the military member. So the person asking for leave is your employee. The person in the military serving is not your employee. So if I've got a parent or I've got a child who's gotten short exigency short notice deployment on 7 or less days, 7 days or less notice, I can come to you and ask for and you'd be obligated to give me FMLA leave. Same for attending military events and related activities such as official ceremonies, programs, informational briefings, or family support or assistance programs. Again, all relating to the military member's deployment. So again, I'm your employee, then I'm in a next of kin, I'm in a familiar relationship with the military member, I would have the right to FMLA leave. To obtain certain and arrange for certain child care and related activities that arise from the military member's covered active duty, including arranging for alternate date care, helping with the children. And here the employee taking the FMLA exigency leave does not need to be related to the military member's child. So I'm your employee, I'm in a familiar relationship with a military member. I don't have to be related to that military member's child, but if I'm the parent, son or daughter or next of kin of the military member, and there's a need to arrange for child care as an exigency for a military member who's deployed, that comes under the FMLA leave. This example specifically is addressed in the regulations for exigency leave relating to the covered military member's duty related to care of the military member's parent who is incapable of self-care, such as arranging for hospice care, alternate care. Again, I don't need, the regs say that your employee does not need to be in a parental relationship with that parent who needs the custodial care. That person has to be a parent of the military member. If I'm your employee and I'm in a relationship with that military member, I get leave. And there's additional exigency leaves, counseling sessions, financial legal arrangements, spend time with the military member who's got taking a temporary rest and recuperation leave during a deployment, and then certain post-deployment activities. So that one is true. Another one under the military leave FMLA amendments. So your company has 2 employees who are siblings. Your 2 employees' siblings have a 3rd sibling who is currently a member of the armed forces. Both employees, now in the exigency leave scenario, you're up to the FMLA, you're up to 12 weeks. So your 2 employees who are siblings have a 3rd sibling who's currently deployed. The employees ask for up to 26 weeks of leave to care for their service member sibling who sustained a disabling injury in the line of duty. Both of your employees, the 2 siblings, both of them are entitled to the leave, true or false? Fast forward, the answer is true and false. It depends. So the regulations provide for next of kin notification. If in his or her military papers, the service member has identified someone who's next of kin, and it could be someone in a more distant relationship than the siblings, the regs speak of a cousin, then if there's been a next of kin designation by the military member, then that's the next of kin person is the person who's entitled to the FMLA leave to care for a disabled or an injured military member. However, if the military member has not designated a next of kin, then all family members with the same level of relationship to the service member are considered the service member's next of kin and may take FMLA leave to provide care to the service member. So in the scenario I gave you, if your 2 employees who are siblings have a 3rd sibling who suffered a disabling injury during active duty and there's been no designation of next of kin, those 2 siblings are in the same relationship to the service member. They are each entitled to the FMLA leave. Under this aspect of the military leave amendments, it's not 12 weeks of leave we're talking about. They're entitled to up to 26 weeks of leave in a 12-month period, and it's not the same 12-month measuring period that you would typically be using for your other, for that employee's annual leave. So it really starts from the time of the caregiving responsibilities for the military member. One other wrinkle to this is that although the amount of leave for military caregiver is increased to 26 weeks, that under the regulations is the total amount of protected FMLA leave that your employee may take in a 12-month calendar period. So if that employee has already in that 12-month calendar period taken, say, 10 weeks for his or her own FMLA leave, they would have available as caregiver for a military member an additional 16 weeks of leave available. But you could be faced with a scenario where there's no next of kin designation and you've got siblings working for you. They would each be equally entitled to take up to 26 weeks of leave to provide care for a covered service member.
So 26 weeks, it doesn't have to be concomitant or something? Like one
Well,
do their 26 and the other do their 26?
That's, and I don't know the answer to that. I was thinking about that, whether they can take that leave concurrent. And I think that goes to the issue of how much care needs to be given. It would be, I think they would have to, if they were going to both say, we're going to take our 26 weeks concurrently, then I think the employer, and I don't know specifically, Carol, under the regulations, whether the regulations address that or whether there would have to be a demonstration of the need for two people as opposed to alternating days or alternating shifts. But they would each be, it's clear that under the regulations, if there's no next of kin designation as the employer, you could not say, all right, well, you, sibling A, you can take care of your brother, and you, sibling B, you work. They each have equal rights unless there's been a next of kin designation.
Well, it is totally appropriate to ask for medical certification. And so you would be looking for information from the doctor of the injured person to find out if, in fact, both siblings are required to be out of work at the same time.